Thank you, Chairman Welch, and thank you, members of the subcommittee, for being here and everybody in support of this bill. I'm David DeLugas. I'm a Georgia attorney. I've been licensed since 1984, and I practice almost exclusively in family law. In addition, I founded in 2013 an organization, a 501c3, called the National Association of Parents, which our DBA is Parents USA, and we represent the interests of all parents in America using only the US Constitution as our foundation and guide. I would note for the members of the committee that last week on December 7th, at the request of a North Carolina attorney representing a mother, we filed an amicus brief in the US Supreme Court. And part of that directly addresses the issues before this subcommittee. First, Parents USA is a secular, nonpartisan nonprofit located in Atlanta, and it exists to serve all legal parents, mothers and fathers, married or unmarried, biological or adoptive, and their children. One of the missions, and the primary mission, is to preserve and support the parent-child relationship by protecting the constitutional rights. It's our position that when children are deprived of significant time with each of their fit parents, children have poorer outcomes on all measures of behavioral, emotional, physical, and academic well-being, and their relationships with their parents and extended families. And such poor outcomes include drug abuse, depression, teen pregnancies, misbehaving, deficient academic performance, and increased incidence of physical health issues. And better outcomes come from parents having significant roles in their parents' lives and parents making the best decisions they can based upon their natural bonds of affection, which is what the US Supreme Court recognized in the case that everybody probably should know or does know or should know about, Troxel v. Granville, a 2000 decision that was a plurality opinion. And we take the position that because of these better outcomes for children, when they have significant parenting time with each of their parents, and by the way, for those who don't know, parenting time is the term now used in lieu of visitation, because visitation was fairly insulting to the non-custodial parent. Our position is that trial courts must not be permitted to intrude and to micromanage families by imposing custody schedules that undermine the parent-child relationship. So to that extent, let me talk, the phrase that's in our society this time because of the pandemic is, let's follow the science. And I'd be happy to provide the members of the committee and anybody else interested a copy of the amicus brief. But almost a quarter century ago, 18 expert social scientists chosen by the National Institute of Child Health and Human Development recommended that parenting time be distributed so that it would, quote, ensure the involvement of both parents in important aspects of their children's everyday lives and routines, including bedtime and waking rituals, transition to and from school, extracurricular and recreational activities. And I have a citation for that. And I won't take the time to read the cites, but I have all of that. And in social science, child well-being or outcomes are derived from these categories. And I just listed them, but the literal ones are academic or cognitive outcomes, including grades, attentiveness in class, and tests of cognitive development. 2, emotional or psychological outcomes, including depression, anxiety, dissatisfied with their lives, or having low self-esteem. 3, behavioral problems, including misbehaving at home, hyperactivity, teenage drug, nicotine, alcohol use. 4, overall physical health or stress-related physical problems, sleep, digestive problems, headaches. And also 5, the quality of parent-child relationships, including how well they communicate with and how close they feel to their parents. And I can go on and talk more about those studies, but in respect for everybody's time, I'm going to be happy to speak to individual members or the committee at another time. One of the issues that comes up, and one of the reasons this bill is before you, I submit, is that because when one parent is awarded substantially the vast majority of the time with a child, that parent becomes the de facto, quote, gatekeeper. Gatekeeper is a term everybody should become familiar with. The problem with gatekeeping is that that's when the parent says, oh, sure, you can go spend time with your father, and sometimes with your mother. It's the other way around. The North Carolina case is actually one where the father was the custodial parent, and he was the gatekeeper empowered by the court to allow the children to go with their mother anytime the father said so. And that is very often the case with mothers in the state of Georgia who have the vast majority of custodial time. The problem with that is if the the parent who's the non-custodial parent doesn't battle for more time, a child feels like they don't care. But when they battle, they're battling with the child's parent. When the child's parent denies access to the non-custodial parent, the boomerang impact that most of these custodial parents don't recognize is the child resents them and later in life ends up being estranged from the custodial parent. So this concept of gatekeeping is created by the courts, the trial courts, and so that's an issue. Now, obviously, if people aren't aware, about 50% of all cases filed in superior courts throughout the state of Georgia are divorce or domestic cases. Therefore, there's a huge burden on our system. And by the way, one of the goals, I think, of the committee should be to find a bill that will pass muster with the Council of Superior Court Judges. They don't want their power curtailed, but they need their power curtailed. And in essence, what I submit the bill when it's revised, and I do think it needs some significant revisions respectfully, as well as OCGA 19-9-1, which is the statute that provides for parenting plans, what's to be included within parenting plans. And candidly, part of the language in this bill needs to be in 19-9-1. And then the child support statute also needs to have some language in it that references parenting time deviations, how it would be affected by the parenting time allocated. Here's the thing about kids. This is from one of the studies from the American Academy of Child and Adolescent Psychiatry. Quote, children often believe they have caused the conflict between their parents. Many children assume the responsibility for bringing their parents back together, causing the children additional stress. Vulnerability to both physical and mental illnesses can originate in the tragic loss of one or both parents through divorce. Now look, trial courts are charged by the state as part of a divorce to award custody jointly or solely, and then to figure out this parenting plan when parents can't agree. But here's what happens, and I do this both from my own experience and vicarious experience in my studies as well. Trial courts fail to consider the harm they're doing children by the parenting plan they're imposing on them. They only use the magic bullet words of best interests of the child, which according to the US Department of Health and Human Services Administration for Children and Families, Children Bureau, there is no standard definition of best interest of the child. And by the way, most people don't know this, and in fact, a lot of judges don't pay attention to it, but in OCGA 19-9-3, the statute that's the subject of this bill, it actually says best interest of the child, and it says and to promote the welfare and happiness of the child. And trial judges don't do that. If you read orders, they almost always just say, well, it's in the best interest of the child. But in order to promote the welfare and happiness of the child, judges need to pay more attention to the impact of the parenting plan they're putting forth. And too often they use best interest of the child. And now trial court judges and family law attorneys, and I'm one of them, understand that as long as the trial court judge uses the phrase best interest of the child and then says, quote, in order to prevent harm to the child, anything that follows those two magic phrases, the Court of Appeals in Georgia is constrained to overturn. In fact, there's a case from 2011, Blackmore v. Blackmore, I have no connection to it at all, in which the father and the mother were both prevented from attending extracurricular activities of the kids, school athletic events, dance recitals, anything, if it was not their parenting time. The impact of that on kids is devastating, and I could speak to that. But my point is, on appeal, because the father appealed, the Court of Appeals said, well, we can't touch it because the trial court said it was done in order to prevent harm to the kids. Not everybody can afford to bring expert witnesses in. Not everybody can afford to even litigate, much less hire an attorney. Therefore, we need to be considering not just the high asset divorce cases, high income cases, where they can hire the expert witness, they can spend $50, $80, $100,000 in legal fees, which is not unusual, by the way. But the other problem with that is judges still do what they want to do because they have the latitude under the law to do honestly anything they want to do. I am actually, this organization and I personally as a family law attorney in Georgia, the social science doesn't actually speak to equal shared parenting. It speaks to these outcomes, these poor outcomes are come about when children have less than 35% of time with one parent or the other. So the bill I would propose would say that the trial courts must provide a minimum of 35% time with each parent, so 35 to 65, somewhere in that continuum, based on the logistics of the family, how far apart they live, the work schedule, the child's extracurricular activities, the location of friends, extended family. This gives trial courts more latitude, but understand that if you're going to go below 35%, which according to the social science is the point at which these poorer outcomes statistically arise, then the court has to justify it by clear and convincing evidence and not just be making it up. Incidentally, Chairman, the other part is that the trial courts and lawyers, we've all come to understand, quote unquote, the standard visitation schedule. That you hear that term every day in every superior court dealing with family law. Why? Because courts have come up with the every other weekend. Now it differs from judge to judge, and we have so many superior court judges in the state that you could have the exact same case in two different counties and have wildly different outcomes. Why? Because for one judge, standard visitation is 6 o'clock Friday to 6 o'clock Sunday every other weekend. For another one, it starts after school on Thursday to Monday morning. And it just varies from the judge to judge. Here's the other reason that legislature needs to provide guidance. And by guidance, I mean boundaries, gutters for these judges. As I was talking with, and I won't name him, but everybody knows who this lawyer is. He's a fantastic lawyer, family law, well reputed. He and I were chatting about it, and he said this. Last week, a buddy of mine was a lawyer practicing law in, happened to be Decatur. This week, he's now a family court judge because he got appointed to be a superior court judge. And he had never practiced family law, but now he is making decisions about people's families, kids and parents. And that is true. In Fulton County, we have the family division. Well, what's interesting about that is Fulton County Superior Court judges rotate in and out of family court. And I will tell you, some of the judges that rotate in never practiced family law as a practitioner, and during their time on the bench, never heard a family law case. So when they get transferred into family law division, guess what? They have no idea what they're doing as far as family law, what's the best interest, and they're going to be over relying upon the lawyers in the courtroom, which means whoever knows the judge better or who's considered the more reputable lawyer, not the evidence. The evidence doesn't matter. It doesn't matter very often, and it shouldn't matter, because one of the goals I submit we should have is to reduce the battles between parents. And as it came up, money is always a problem. So one of the things that needs to be clear is if the motive is let's help the kids have a better childhood, and I wrote this in something every day a child is hurt, every day a child loses any part of his or her childhood can never be restored or replaced. That means that in these cases that go before the courts, why? For a divorce, for a legitimation in a custody schedule, why does it take 6 months, a year, 2 years, 3 years with repeated modifications over time? Why? Because parents can fight. If you allow parents to fight, if you give them basis to fight, if you give them reasons to fight, they will drain their bank accounts. Lawyers will enable and encourage them, and sometimes rightfully so. And other times it's just a futile effort. So I submit that we need to look at 1991, 1993, 615 on child support, so that the parenting time deviation addresses these issues, so that we come up and either that or the Child Support Commission revises the data calculation so that standard visitation, which is what they use. By the way, Chairman, the Child Support Commission creates an Excel worksheet where you plug in income and health insurance premiums and other things, and it spits out this is the presumptive amount of child support. Now, how did the Child Support Commission come up with that? Well, they decided what is standard visitation, and here's the costs and the relative costs and this and that. But my point is they're using something based on, quote, standard visitation, which presumably is what the Superior Court judges are doing. We've seen a decrease in the amount of litigation when it comes to child support when the child support worksheets came out. That was a good thing. That's the legislature telling people what your child support is presumptively. So this bill would do the same thing, although I agree with you that family law lawyers and the Council of Superior Court judges are going to oppose 50-50 as a presumption. But I do think there should be a presumption that not less than 35%. And again, we maybe need to look at these social science studies so you can see what I've seen, would then create the situation where vast majority of cases will be between 35 and 65 for each parent. And only rarely would it dip below, and then there would have to be some compelling circumstances to justify doing that. And my last thought on this is, you should expect the family law section to not endorse any bill that would reduce the amount of litigation and fighting between parents, because that affects pocketbooks.
I'm gonna let me just interject there.